planning on one news and one success story as always, but just this week, something crazy happened. Our client got a fine by the Department of Homeland Security, right? It's right here. Department of Homeland Security sent the client like these 2-3 pages, and they now owe $1.8 million. 1.8, it's crazy. 1,820,000 plus. And this is under the, what is it? The law is, INA, the 274D. It looks almost fraudulent, right? And the staggering amount is almost unreal. And we knew it was coming, and they announced it. But a lot of times with government, sometimes they announce things and it doesn't go out, it doesn't get rolled out. Like the Real ID, right? Like it took 10 years before any meaningful action is taking place. But to scare immigrants, there is no end, right? And so immediately these things are rolling out. We got it. We're getting calls about it. You only have 15 days to respond. You only have 15 days to contest this $1.8 million fine. I'm just going to read some of the language that they write. If you do not timely file a written notice of appeal, the notice of violation and order will become final, and you will be liable for the assessed civil penalty. You have 15 days to appeal this $1.8 million that you just got in the mail. What if you're on vacation? What if, you missed the mail for like 3-4 days? Suddenly you're liable for 1.8 million, and then they could put it into civil proceedings and then to freeze your assets and then to confiscate your house and put a lien on your house. This is pretty intense. And what is the most annoying thing about this entire process, and I'm saying annoying very nicely because what I really mean is how unjust and unfair and insane this process is that I know for a fact a lot of people are getting this when they shouldn't be getting it. Okay? So if you are an incarcerated criminal who have been deported and you have, all sorts of things, and the government is 100% sure that you are out of status and you're in violation and you are, wrong, and so they impose this penalty on you, and then they freeze your asset. That's one thing, right? That's what they're doing to U.S. citizens that they're trying to denaturalize, at least from my reading of it, right? The 300 naturalized citizens that they're going to try to denaturalize. But for people who are undocumented, for people who are in the process, in limbo with this immigration system, they're just sending these notices out, And what do I mean by that? If they see on the court docket that there is a final removal order, they say, haha, I got you, right? Years ago, you got this final removal order, so we're just sending you this notice. And then you have 15 days, and we're going to send it to the last address on record. That is their system in which they are sending these $1 million fines, and you have 15 days to respond. If you don't, it becomes final. How insane is that? And the reason why it's so insane is because so many of these cases can be contested, should be contested, ought to be contested, right? The last address on record, that might not be their record. You might send it to an attorney, and the attorney might send it to the wrong person. The final order to be removed might have been an in absentia order in which the client didn't even have a chance to appear in court to represent themselves. So they didn't even know they have been deported, and they don't even know there's a removal order against them. So because we've seen so many of these cases over the years where final orders of removal, in absentia orders, are there when clients don't even know. Some of our clients have already left the country, right? Like, for example, the last live that we did last week, our client came in as a tourist, left the country, got a removal order. Had we not go to court, fight for it, get that case terminated, they would have had an in absentia order, and then they would have, got this notice, and suddenly they are being fined. And according to the trial attorney from last week, they wouldn't check the system necessarily, and so maybe they'll be like, oh, well, you've been out of the country for 30, 40, 50 days, so we're going to give you this bill. A lot of tourists have property and bank accounts in the US. And so now with this civil fine, they can now freeze the assets. How insane is that? That's the United States immigration system for you. And so because our clients got this, we're going to fight it immediately. We're going to, and let me just share a little bit about how to fight these type of notices, right? Because you want to prove that this notice is wrong, right? That removal order was wrong, right? They didn't have proper representation, or the better argument is I couldn't leave, right? You are fining me almost $1,000 a day, 998 specifically. You're fining me per day for not leaving. I couldn't leave. I shouldn't have left. I shouldn't be leaving, right? I have a cancellation and removal case that's pending. I have an adjustment case that's pending. I have a case that is being reopened at immigration court. I shouldn't leave. If I leave, everything will be withdrawn. And so all this time that you calculate that you're finding me for staying in the US shouldn't be counted. That is the argument you want to immediately file. I'm recommending everyone to do this. If you get this order within 15 days, appeal it, fight it. Because if you don't, it's an additional grounds for the government to now confiscate your property. Now, if you don't have any property, if you're living under the radar, getting an extra notice, whatever. But if you have a valid case to fight in immigration court, if you have a 42B cancellation removal course that you can fight, you just didn't know how to do it, you were just putting it off, it's worth fighting for it, right? And then you definitely don't want to win the green card, but suddenly owe $1 million, right? Your call, but that would hurt a lot. You have this 15-day window, right? So the government, updated their civil penalty rule, and so now you only have 15 days. Before you had a lot longer. Before it was only $500 per day. Now it's $998 per day. If you check into a 4-star resort in New York in Christmas time, a lot of times that is like almost $1,000 a day for a hotel. This case, you're just staying in the country, breathing the air, and now you're being charged $998 per day. It's pretty insane what the US government is doing. Like, the rest of the world cannot believe this is happening. It looks fraudulent, but it isn't. So I just want to share with people who are getting these type of notices, it is not a scam. Although I totally believe scammers will be out there replicating this and asking you to pay them instead of the government and saying, hey, we'll give you a discount if you pay us with a Target gift card or something, right? That would be terrible, but I could totally foresee that happening, right? So we're gonna put up the notice, the formal notice that is real, so you could see it. Of course, we'll have to block out the client's names and stuff, but you'll at least see what a real notice is like, and you will be able to see, well, what are they requiring and the basis of this, right? And how to fight it. And again, how to fight it is you want to fight the final removal, saying that was improperly served, right? You never got it. The attorney got it. One of our clients, actually, it's crazy. The attorney got the removal notice, but stopped representing the client, forwarded it to the client's address, but wrote the wrong unit number to the apartment. So the client never got it. And we were able to get that file from the prior attorney. So now we could say, hey, look, our client never officially got it. So this final notice does not go into effect, right? But anyways, you have to fight it. Just gotta. Okay, I'll take some questions and then I'll get to the second story.
Okay, so we'll take some questions. Feel free to put them in the chat. First question. Happy Thursday. Good morning, King. Okay, not a question on that. What are some challenges that you regularly encounter when working with clients?
Challenges I encounter. I think for most people who don't understand the field of law or immigration law and stuff like that, emotional connection and getting documents is actually 30, 40, 50% of the battle, right? Let's talk about waivers. You're unearthing past trauma. You're unearthing a lot of sensitive information, right? Maybe you're dealing with a client and their husband or their wife is getting deported, but now you have to dig up to their past, talk about their prior marriages, talk about prior relationships, talk about sexual abuse. It's very sensitive stuff. And sometimes they're doing it together, some of their kids are involved, but you need to elicit information and documents in order to build the best case you can in order to file. That is not something you learn in law school, That is very important. If you're doing an L1, an EB1 case, you have to elicit information from the company. And a lot of times, a lot of good companies are like, I'm not going to give you our trade secret, right? How are we going to expand in the future, and how are we going to compete with US companies? We're not going to give you our business plan. Like, what do you mean? But we have to get it in order to argue that they are going to create this enterprise and they're going to hire US workers and it's going to benefit the US economy, right? So there's a lot of things that's getting stuff from the client, and that is a daily challenge. It's not just filling out a form and collect a few documents and then filing it, right? If you want to prepare a case, you want to prove the marriage is real, you're going to talk about their marriage, right? And if you're doing removal defense stuff, they're about to get removed. There's a lot of emotional trauma that you have to guide them and their family through. So I would say that is definitely by far the biggest challenge for our team, for our clients, for our work process. And this is something that AI can't solve, you know? So if you're just a, AI salesperson, right, that contacts us every single day, they're like, oh, we can make your workflow much faster. This human to human aspect cannot be replaced. And once we get the case, a lot of times I have to talk to the officer. I have to talk to the CBP officer at the border. I have to, go with the client to the interview to talk to the officer there. ICE check-ins, talk to the ICE officer. There's a lot of times where you have to present things. AI can make, the law a little bit neater, right? But at the end of the day, it's still a very human process.
My husband's DACA expires next month. Aside from filing claim and contacting our senator, is there anything we can do? This process has just been so exhausting.
I understand. There's not much more you can do. You can file it. Well, today's success story is about how to get something expedited. In our case, it's an advanced parole that we got expedited, which is nearly impossible in the past 4 years, but we got it this time. You could use some of that strategy in your DACA case. Not exactly the same, but the actions are fairly similar. I know it's really exhausting, but believe me, a lot of things are way worse in this immigration climate, right? Trying to get a cancellation removal in court, trying to get bailed out by ICE, trying to come back into the country when you've left the US for a year, 2 years, even as a green card holder. Those are all really big nightmares compared to filling out the DACA extension form and trying to get it expedited. I know it's hard because you have to take time off work, you have to talk to your employer, but compared to so many other things, you guys are on the fast track lane already. And hopefully, next administration, in the next few years, there's going to be a policy that's going to open it up so that they can get a new path to citizenship.
I'm 24, and so this is about asylum. I'm worried about going back to my home country due to FGM concerns. There's threats, and there's been witness statements from friends confirming that. Is my case strong?
We don't do asylum cases at the firm, so I really am not the best person to answer that question. Loosely, though, I've heard that if your asylum case was 5 years ago, 10 years ago, conditions have changed significantly, and then you go back and then you come back in, the customs officer is not going to give you as hard of a time. If you were a dependent child of somebody who got the asylum claim, right? You were not the one who primarily filed it. It's a little bit easier. But if you just got the asylum and then you're already going back, that might be a problem with customs. And so you still want to prepare well and explain it to them, right? Now, every custom officer reviews these differently. There's a lot of luck involved, but if you leave, you have a weak case and you meet a very difficult and strict officer, you might be in a host of troubles.
I got my NTA in 2028.
Okay.
I'm on Wawa now, maybe Vawa.
You got your NTA in 2028? You're from the future? 2018?
Perhaps. On Vawa or Wawa. Now I got work permit, but USCIS denied my travel document. Yeah, in 2018.
Okay. 2018, denied travel document. You got an NTA, so presumably your VAWA application now has been denied. And now you really want to prove it in court. Getting your travel authorization denied is fairly common. We see that very often. So that's not abnormal, right? If you're out of status, like, and then you file for a adjustment of status based on any sort of claims, they usually don't like to give travel authorizations, and occasionally they give work permits. Especially if the cases take a long time. But if your VAWA claim has been denied at USCIS and now you are in front of an immigration judge, you have a second bite of the apple. Try to make the argument again. Obviously, it's much harder, but try your best, right? And if that doesn't work, look into 42B, cancellation or removal. Obviously, because you got the NTA, the time stopped. So hopefully, you've been in the U.S. for more than 10 plus years, so you can make that kind of argument. Those are things that off the top of my head.
I'm from one of the 39 banned countries. I currently got selected for H-1B and have valid STEM OPT. Do you think my H-1B application will be approved?
You are, because of the FUF2 federal, you know what? Great question and great segue into our second story, right? So the second news is about this 39 country ban and the 75 country ban at that. And to answer your question directly right now, there is a chance, there is a window of opportunity. And let me explain. There's a lot of lawsuits that's filed against this 39 country ban. I forgot how many, but like hundreds, I believe. And two of the judges already ruled that this indefinite pause on all benefit requests is a violation of immigration law. And so there's a preliminary injunction on this issue, which means essentially that order shouldn't be taken into effect, and USCIS should continue to adjudicate these cases reasonably. So, you filed the H-1B, you got selected, you file it. For everybody else, maybe they'll process it within a month. You pay for premium processing. If you don't pay for premium processing, maybe it could take 3 months, 6 months. That's normal processing. In your case, because you're part of 39 countries, they take a little bit longer than that. That's within reason. But an indefinite pause on application is right now unlawful, according to the judge. And so there is an injunction against that. So if I were you, I would file, I would push as hard as I can. Now, if you are part of the exception, all the more power to you, right? And so USCIS just released it on their website, right? If you're a physician, you qualify for exception. So you should file and you should press for any sort of national interest exceptions to argue you shouldn't be paused. That's for the 39 countries. And for 75 countries, it's still a lot of litigation. It's still paused. It is much harder to challenge that because it is directed at the consulates and talking about green cards, and that's within the realm of authority of the government, the executive office. So again, my prediction is that the 75 countries, it's still going to continue. It will probably take another 2 years, 3 years, or 4 years. More countries might be added onto the list eventually. That's my theory on that. You could try to qualify for different exceptions. You could try to get a non-immigrant visa, come to the US, and then file for adjustment. But that's so far the only pathway that I've seen that works. But for the 39 countries that have all benefits paused with USCIS, this lawsuit is a window of opportunity. And we do have some clients that their O1 is paused indefinitely, and so they're going to file a mandamus, right? So that's like kind of like the next step, right? Like they're supposed to adjudicate it reasonably, but how come it's taking so long? You can always file a mandamus to sue the government to move a little faster. Okay, that's the second news story. Yeah, that was kind of short, but hopefully that helps. I'll take some more questions before we get to the success story.
Yeah. How long will the re-vetting process take?
Years and years. And from all my exposure and experience with USCIS and talking with them, it will likely never fully finish. Because if you imagine what their office's job like, and let's just talk about the past like 5 years, 10 years, right? There's a lot of people with a furlough. So a lot of US officers left and took the payout. Suddenly Afghanistan war, suddenly Ukraine war, Afghanistan withdrawal, all those I-131 applications had to pull through, and USCIS put on expedite notice to process those cases. So while they're doing that, they're doing everything else with a limited amount of staff. And then Trump 2.0 comes in and says, all business immigration cases, now you have to adjudicate those in person as well. You can't just, you have to schedule them. So something that took 8-10 minutes, now it becomes a 2-hour, 4-hour ordeal. So with less people, with more work, everything getting delayed, and suddenly, again, a new executive order comes out. Hey, re-adjudicate all past 4-year cases. They're already way, way backlogged with less people. How are they possibly going to go back for the last 4 years without any, personnel increase in sight and without much training in sight? So that's now. A couple months later, a new executive order comes in and another big change happens. Another war breaks out, God forbid, right? A bunch of Cubans flee and come to the U.S. and now we have to do an amnesty for Cubans or whatever, right? Like anything could possibly happen, and everything does happen every so often. And so USCIS's work is just perpetually getting bigger and bigger and bigger. And so if your question is, as it's getting bigger and bigger and bigger, and suddenly they have to re-adjudicate all green card applications from the past administration, which was a lot, by the way, will they ever finish? My answer is probably never going to finish, right? They're probably going to do an AI scan of a lot of things, the most problematic ones, pull out, re-adjudicate some of those. But to fully comply, finish, because of all the new things that's coming along. Now, if you are in one of those situations, if your green card was approved in the prior administration and you're concerned, my advice to you and my advice to a lot of clients is that you will probably be adjudicated, quote unquote, re-adjudicated when you apply for citizenship, right? So when you are applying for citizenship, now they see, oh, the 5 years ago, you were part of that administration, you're part of that bucket. Let's re-adjudicate your green card application right now anyways. They're already doing that, even without the prior Biden administration. I mean, from a couple of live sessions, a success story we did, there was a client who got their green card like 20 years ago. They applied for citizenship and their citizenship got denied and their green cards got denied, revoked, and they had to reapply for a green card because 20 years ago it was adjudicated incorrectly. So that is all happening, and that is my theory of what is going to happen, right? There's a smaller chance of an officer or a department fully just going through the 4 years of work to re-adjudicate it. They're trying to catch fraud, right? But most officers are just so backed up already. By the time you apply for citizenship, that's the time to re-adjudicate.
What is the safest way to send very important documents from, like evidence, from Egypt to the U.S. and have it be reliable to USCIS? DHL, FedEx, USPS, UPS?
I think it depends on what the document is. I remember there are certain evidence, like such as DNA samples, that you have to do a special service through the DNA agencies. So you can't even do it, right? So you have to prepare it, send it to the agency. The agency will put it in a airtight frozen box, and then they send it over, and then they mail it to USCIS directly. Other things at the consulate, you do it, the consulate will send to USCIS directly, right? So there are certain things that you have to use an agency to do. If it's like paper, you could scan it and USCIS will get it, right? So a lot of documents you can upload now, right? Different type of cases, even EB1A, you can scan and upload as well, right? Now, if it's something that has to be mailed, which is very few because most evidence, they don't want original documents, right? When we send documents to USCIS, they don't want original documents. They don't want the liability of that. We scan everything, so we have a full record, and we send in scanned copies. So unless USCIS is somehow requesting for like originals, which sometimes they do, then send it in. And in that case, when it's something super highly sensitive, we usually use FedEx.
So this is a follow-up on the NTA from 2018.
Yeah.
On VAWA, have work permit, USA denied travel documents. I have before advanced parole by marriage.
Okay.
Can you help me remove my NTA?
If you have a good basis, yes, we can. If you don't have a good basis, we can't. And what is a good basis, right? Removing NTA is called a motion to terminate. And last week we did a success story on that, right? And the idea is, please take this off your calendar, judge. This is a waste of time. The client has a case already with USCIS, already another marriage application, something that is already there. This was a system glitch. They shouldn't be in this proceeding in the first place. You have to have some basis, right? If you don't have any basis, you can't just say, hey, please, don't deport me. So we really should do a consultation to kind of analyze. Now, if you know you don't have a good basis, there's nothing we can really do, right? But if you still want to talk, we're happy to do that. But I'm just saying, like, we can only do cases where there is a basis to file the motion to terminate.
Do you think the recent physician exemptions from the 39 country ban can help support future physicians to come from outside the US and avoid the $1,000 fee, since the lawsuits haven't done anything?
Yeah, yeah. I mean, we got national interest exceptions approved before all of this, right? So U.S. is in always a big shortage of healthcare, and so if you can get really strong letter of recs from U.S. agencies, right, that makes a big difference, right? If like the whole hospital, if Kaiser, if there's official doctors from there that is writing a letter rec saying that you individually need to come to help with this particular surgery or this type of change, it makes a pretty big difference.
I heard there's a pause for all renewals with USCIS. Will this impact I-90 form renewals expiring in June?
It is definitely not paused. We have been filing and we're still getting cases approved and we're getting requests for evidence for some of them. And so renewals are definitely not paused. It is getting a much stricter. We're seeing requests for evidence that we've never seen in the past like decade. And so it's definitely getting a lot stricter, but it is not paused.
What do you think about, do you recommend starting a I-130 601A process for a spouse at this time, given this administration?
The process itself is going to take a long time. So by the time it's being adjudicated, it's probably out of this administration. But what does that mean? It could get stricter, right? Because the people that retire now, then they get trained. Then they're fully trained and ripe officer who's super strict suddenly reviews your case, right? And so they all go, well, then maybe I'll wait like 10 years later to file. Then you're gambling on the future, right? So I would say just ignore the noise, focus on your life, live your best life, and build your best case. And when you should have the confidence to win any case, right? Doesn't matter what officer, a white officer, a black officer, an old officer, a young officer, a trained and untrained, a prejudiced, an unprejudiced officer, a Republican, a Democrat, doesn't matter. I'm going to build my best case and I'm going to win this case regardless. That should be your mentality.
With the toughness and unpredictability of the current situation, what is the possibility, in percentage, if any, of the success of rebutting the presumption of break of residency for naturalization?
Oh, say the whole thing again?
Yeah, so this is about rebutting the
Yeah.
presumption of break of residency.
Right.
What do you think, in abstract, the possibility and the percentage chance is?
What are the facts?
Just in general. Yeah, feel free to put your facts, but just in general.
Yeah. Out of the blue. I mean, we have so many success cases, and we have so many cases that were challenged and denied. So, I mean, but we try some of the most difficult cases. I don't know. It's too hard. I would say this though. It depends a lot on the officer. It depends a lot on the jurisdiction, right? New York, California, San Francisco, they're all adjudicating things differently. Vegas has historically been a little bit easier. So in the past, we have seen clients move to Vegas, prepare a case, and file there just to get it approved. I know it's crazy. That's what people have done. Now it's getting a little bit stricter. San Francisco has always been really so one thing is just kind of figure out the you know the location, and the second is building a really solid and good case, right? And some officers they see it, they're like, okay, I'll prove it, right? Even though you've been out for a year, that's great, right? Sometimes you have to fight it 2-3 times. So, is it possible? Yes. Is it hard? Yes. Um, is there a problem if you get denied? No. Just file it, do your best. If it gets denied, wait a little longer and then refile, right? It costs your time, it costs you money, it costs, having to go through the interview, but is that worth it, right? And so for some people, if they left a year, or, if they left 4 years ago and you can use the 4-year 1 day rule, it's like, I don't really want to just try it and just to win myself a couple months. Maybe I'll just wait an extra half a year and then I'll file it, right? Sure. But if you just left you just came back last week and you've been out for over 6 months to a year, maybe a little bit harder to argue. Also look into the N470, right? We were able to use that, win it for our client, and then we're going to use that to file for citizenship. That also works. And we got that approved within a month, right? So you could file for N470, get it approved for a month, and use that for the N400 to argue the breaking continuity. So many things to consider to do.
What about in California, like Los Angeles?
I would say actually Los Angeles is okay. It's not the strictest. I definitely think San Francisco, Seattle is way stricter than Los Angeles, but it's also not the most lenient, and a lot of theories why California and New York see a lot of people who leave the country for a significantly long time, and so they're understanding of that. But because they also see a lot of that, you should definitely prepare really strong evidence why the U.S. was your home. You didn't abandon it, and it was out of your control. And did you apply for a reentry permit? All sorts of things that they really want to see, and so you want to be prepared to kind of explain all of that.
What about Ohio?
Anywhere that they don't see these type of situations, I would think it's hard because they just go by the letter of law. Out of 6 months, sorry.
Oh, it's 6 months, 11 days.
I've seen cases denied for 5 months. It's completely unfair, but I've seen it happen.
Have you seen anyone get the national interest exemption for H-1B since the 100K fee came out?
We haven't done it. I'm sure I've seen it on the listservs, but I didn't follow up.
Yeah. So just seen it talked about.
Yeah.
So it has happened at least once.
I want to say it's again. I'm just scrolling through listservs. I'm just reading other people, and I don't know if it's real, if it's not real. I think they said they got approved, or they're doing it. But yeah, I don't have a real case that I could really talk about.
I have a green card. My girlfriend is from Canada. What's the best and fastest way to get her to the U.S.?
You are a U.S. citizen.
Green card holder.
Oh, you're a green card holder, and she's Canadian.
Yeah.
What's the fastest way to get her here? You can get her here in a matter of 2 days with a TN visa. There's a lot of risks to it, but if you do it well and the officer's understanding, get her here while she's on the TN visa, apply for the I-130. Once the priority is current, apply for the adjustment status. Then she has a work permit and a green card waiting. But if you want her in ASAP, TN is the fastest, then it's the E2. Those are the two non-immigrant visas that could probably get her in as fast as possible.
And both of those are employment visas, right? So she needs to have a job or invest.
That's right. So, use ChatGPT, kind of understand a little bit more, but we've definitely seen and helped clients do that. F1 is also really fast, being an international student. But being able to be here, be really good, establish yourself, establish your residency, then the I-130, then the green card application, then they get the green card.
Can I apply I-130 for my wife and 6-month-old baby living abroad?
Say that again?
Can I apply I-130 for my wife and 6-month-old living abroad?
What's your status? Are you a citizen? Are you a green card holder?
Let's say citizen.
Yeah, well, so the reason I'm asking is because if you're a citizen, you could directly pass your citizenship to your child, so they don't even need a green card. If you're a citizen, you can directly apply I-130 for your wife and then get them go through the process together and get both of them green cards. If you're a green card holder, and assuming she's not a green card holder because you're saying you want to apply for it, but if she was a green card holder, once she gives birth, she could pass on her green card to her child through the NA3 process at the border. But we usually go through consulate first and then the border, right? Now, if you're a green card holder and they are not, and we want to apply the I-130 for them, you definitely can, and then you just wait for a priority date, and then they go to the consulate and get both of them green cards. No problem. It's done all the time.
Second question: how about I-730 for those dual citizenships? They put 221G. The options are canceled. 10 years B1 B2 visa.
So you want to go back to the consulate and reapply, and then you might need to apply for a waiver. And you might have to be able to convince the officer that you deserve this waiver. Why do you need to come to the US? And is it in the best interest of the US to give you this particular visa, whether it's a tourist visa or another type of visa, right? But right now, that situation, the decision is all the way at the consulate. So you have to prepare your case well and then go through the consulate.
Yeah, someone says, I live in Vegas and my process was a breeze.
Go Vegas. we were so close in opening an office in Vegas. I actually really like Vegas. But we didn't, we doubled down here and created the studio.
So I want to go back to talk about the 39 country updates.
Okay.
Could you go a little bit more in depth on what actually happened with USCIS on their side?
Yes. So let me just, brief history. 19 countries, everything was paused. Non-immigrant visa, immigrant visa, citizenship, everything was paused. It was a big deal. And then they added 20 countries, so 39 countries. And it's been a long time since that ban went into effect. And so everybody who's trying to do any sort of status, H-1B, O-1, L-1, I mean, think about the hundreds of thousands of applications, citizenship applications, green card applications, any sort of benefits that they're applying for, I-130 benefits, like things that normally already take a long time. Now with this pause, it's just adding infinite amount of, not infinite, but just adding a lot more time. And new applications are being filed in, but it's just being held up, right? So the backlog is getting bigger and bigger and bigger. And obviously a lot of people sued because saying that it's unjust. And the court agrees. It is unjust. You can't just inadvertently pause a law. I mean, if the executive branch can do that, that's like tantamount to saying, you know what, let's just pause, execution. Let's just pause, any sort of criminal investigation to this subset of group, right? Let's just get rid of this law completely by pausing it. Then we have a king instead of a president, right? Congress creates the laws. The executive branch must enforce it. You can't just pause an enforcement. You have to enforce it. And so you cannot pause it indefinitely. Well, what does that mean? How long? What is a reasonable amount of pause? That's going to be up for the courts to decide. But that is sort of the situation we're stuck in. And it's going to take some mandamus lawsuits to figure out, well, something that should take 8 minutes, 10 minutes to adjudicate, and they're adjudicating for 4 months for everybody else, and we've waited for 6 months. Is that unreasonable, right? So we're going to see.
And one question I saw online a lot is, okay, these lawsuits came in. There's temporary injunctions just for the initial thing. But now I'm seeing other people are getting their case processed because they were part of this lawsuit.
Yes.
So now obviously we can't give legal advice, but should I join a lawsuit now? Because I'm seeing all these other people get theirs move forward.
The way the judicial system works, the ruling only applies to the people who filed the lawsuit, so the plaintiffs. So if you want your case to move faster, you should join the lawsuit.
Okay. Is O1 feasible for physicians? U.S. board certified, lots of academic and publications.
Yep. Sounds like it's a great case.
Okay, now I want to get into our success story for today. And you mentioned earlier that it relates to one of the questions that someone asked.
Yes.
Could you say a little bit more about that?
All right. So I know a lot of people are stressed about their case because it's taking so long. They want to get things expedited, right? So whether you want DACA to be expedited, you want your immigrant petition to be expedited. In this case, it was an advanced parole that the clients want expedited. And, in the past, there was like a simple solution. Simple, you get it within a few days. Sometimes you get it day of. You work really hard. You spend half a day. You talk to an officer. They understand it. They approve it. It's what you expect the American system to have, right? So if you lived here, you know that that's a lot of how American systems work, right? You show up in person. You make the argument. You go back and forth, and sometimes they approve it. They print it out, and you get it, right? Um, Unfortunately, since COVID, the whole system of advanced parole expediting advanced paroles, expediting reentry permits, expediting work permits has been just such a broken down system into which even if you get approved by the USCIS officer, even if they want to approve you, the system is so broken that they couldn't issue it. And that happened to many of our clients in the past, right? So we're always trying to expedite things naturally. Um, and we finally did it. So, it's not, getting an advanced parole expedited is not one of those huge success stories that deserve a whole dedicated video on it. But for us, it is just so important because it marks a time and place, right? Um, Pre-COVID, we did a lot of it. Since COVID, it was just so hard to do that we almost advise people not to do it, can't do it, but just do it on your own. We can't do it. This client in 2026 just desperately needed to go back because their father was going to pass away. And so even though we told them during the consultation, look, probably not going to happen, it's just so messed up, they said, we just need to try. We can't give up. So let me kind of read you what we did, okay? So the first thing is we filed the expedite request March 2026. So they didn't file it before, right? It's not like we were retained after they already filed it. They just had an emergency situation back in their home country. The entire family needed to go see their dad, right? It's a humanitarian situation. The father might pass away. We filed it March 13th. Then in late March, we contacted USCIS twice. We talked to the officer. We were trying to contact them. They said they were going to call back. They didn't call back. They were going to call back to us. They were going to call back to the client. There was two phone calls with confirmation numbers. It's an extremely annoying ordeal just to even call USCIS. Anybody who's tried it, no. But we did that twice. Then in early April, the client went to get Congress help, right? We said, you could do that. They have an office dedicated to helping people in your situation. It's not too complicated. You show up, you fill out the paperwork. They advise you, and they send an email to USCIS to try to get an update, right? So got congressional help. It's free to the public, right? So, I mean, to the constituents. You can't just go to any Congress office, right? So go to the place where you live. They help you. They file it. That's in mid-April. Then in near late April, we advise the client to schedule an emergency info pass appointment to show up in person to get it. Now, we always do this as a last step because then we have all the things to show that we've tried every single way before we did the emergency info pass. In the past, pre-COVID, we used to just, in some emergency situations, we just go up into info pass and just directly do it with the client, and we argue and we present documents, and so a lot of times officers like, fine, give it. And the thing is, the truth is, there's less people now at these InfoPass appointments compared to the past, right? In the past, these InfoPass appointments look like the DMV, right? Like 30, 40, 50 people waiting in line. They're getting called one by one. You'll wait there for half a day. These days, InfoPass appointments, even in LA, even in New York, even in like crazy busy places, because it's so hard to even get an appointment, when you go to the appointment, there's like 3, 4, 5 officers there, and there's like nobody there. It's crazy that in that situation, when there's nobody there and so many officers, they still don't approve it. But that's bureaucracy. I'm just fed up with it. But the clients made the appointment, showed up. Oh, made the appointment. But before their actual appointment, the last week of April, the case got approved and mailed to us. So we filed it in March, mid-March. So it's about 6 weeks to get the approval. it's crazy how this is what it has led to, right? You first have to do an extensive expedite request. So we wrote out like 3-page attorney brief. We provided all the documents. We explained the medical condition abroad. We translated everything. Um, we filed it. The client has already been waiting for a long time. They need to travel. We made the arguments with the supporting documents. Expedite request, filed it out. Made 2 phone calls, congressional support, expedite appointment. And I didn't even count the endless amount of Emma chats that we did with USCIS website, right? And then within 6 months, it was 6 weeks. Now, 6 weeks in the grand scheme of USCIS processing is actually quite short. You might think it's really long, right? For everything else in the US, like what? You have to wait 6 weeks? That's not even guaranteed, right? We know some travel permits take more than 6 months to process, even on an expedited basis. So 6 weeks is extremely, extremely fast. That's why it's worthy of a success story right here in May of 2026, right? Because it's just so hard to get these days. Now, is there ways to do it faster? I don't know, right? But the reason why it's so slow is because even if the field office approves it, it still has to be mailed out and created by USCIS and their advanced parole agency and their contractors, right? Because again, USCIS, in all their wisdom, believes that it is faster and more efficient to contract it out instead of doing it themselves. But in reality, that slowed everything down. It took the power away from USCIS. Even if they want to approve something, they can't. So USCIS gets all the blame. The contractors still make the money. Is that the wise move? God knows, right? But this has been the past couple years. USCIS contracting out, the I-90s, the I-131s, the 765s. And so, I don't know. I hope everybody who needs things expedited will go through this. And again, if you're just impatient or if you're just annoyed by hearing, well, this is the process to go through, maybe you'll be, more patient, right? You'll just kind of give up. But in this case, the family, their dad is dying. They're willing to do anything to get the case processed, right? And so, anyways, Rebecca did this case. I'm so proud of her. And so I'm glad she was able to get it through. If you guys have any questions, feel free to call, reach out, book an appointment with her, talk about this case. Thank you guys for watching. Take care. Bye-bye.
Okay, and that was our success story. So we'll answer a few more questions. Can I apply for my for F1 visa, besties of 221G, maybe besides 221G, or apply again B1, B2 visa? Place of birth is Afghanistan.
Sounds hard, but you never know until you try, right? And do a good job. Just do your best. We know so many stories of clients getting rejected 17 times and then on the 18th time getting approved. I know personally consulate officers who have denied the cases multiple times and then approving it in the end. So don't give up hope. You might have to apply for a waiver. You might have to build up a case. Every situation is different, right? How you are now is different than how you were a couple years ago when everything happened. And how you will be 5, 10 years from now is going to be different than how you are now, right? So every single time it's a new interview, present yourself, show why you want to come to the US.
Okay, I want to give you a few more fact patterns about this case.
Okay.
So they are holding Norwegian passport.
Okay.
The person has been to the US over 5 times with a visa.
Okay.
They have been, they got their B1, B2 rejected twice. I-730 is still pending.
Okay.
How do I convince the officer to let me, to give B1, B2 visa?
Well, I'm presuming your denial. Well, you know why you've been denied twice, right? And so you have to overcome them. Just flip the situation around. If you were them, right? If you were them, and let's say this is their first job or second job, like this consular officer who interviewed you, they have to put their name on your visa approval. How can they guarantee that you are not going to violate your non-immigrant status, right? When everybody else is violating their immigrant status, how can you almost 100% guarantee it? What do you need to prove to them to overcome it, right? So just pretend you are them. Maybe in some situations it's a job, it's marriage, it's kids, it's there's other things that really sets you apart from everybody else, right?
Yeah, they're saying it's because their 730 is approved.
Right. And so if your 730 is already approved, why don't you just wait longer? Or if you come to the US, what's stopping you from changing your status, right? They want to make sure you go to the US is just a B1 B2, right? Right. And so sometimes we see some clients do this, please just give me a one-time B1 B2 entry for 1 week. I just need surgery. And you have a major illness, and really it's only this US doctor, and based out of humanitarian concern, they give you a parole maybe, and then you go in, right? But essentially you have to provide some sort of rationale and guarantee. I mean, the other way is if they approve you and you violate your status, you change your status, you do something else. If they lose their job for this, they're not going to lose their job, right? But what if they're going to lose their job? It's a stain on their record, right? So you have to put yourself in their position to kind of really think through how to improve it.
Yeah, so they said they went to the interview, but received a 221G. And I'm just checking, is Afghanistan on the list of 39 countries? Is that the issue?
I do think it is, and so you want to get that you want to get that national interest exception, right? And it's really hard, right? Like, why should they do that for you, right? And so, anyways, I just think it's a tough time at the consulate right now, and that the consulate strictly listens to the government, the president in power. It's part of the executive branch, so it's not going to be able to be challenged in court. But like I said, you could just keep on applying, and it adds to your credibility, right, of what you want to do. It doesn't harm you as long as your story aligned, right? If in one instance you're saying you have this humanitarian need to go, and the second is like, oh, you are the lead contractor for FIFA, right? And then later on you want to donate $1 million to Harvard, right? If it starts contradicting left and right, that's not going to look good, right?
But so it's getting affected. So Afghanistan is one of the 39 countries. Right. But so is this getting affected by the travel ban then? Is that what the 221G means?
221G might be a waiver that you need to apply for. I'm actually not entirely sure, but I'm just saying when non-immigrant visas, B1, B2 gets denied, you just want to overcome it, and you could apply again and again. And if the officer is willing to, they can apply for waiver on your behalf and send it to the Washington, D.C., right? Now, the 39 country ban mostly is with USCIS and the consulate for all immigrant benefits, whereas the 75 country is just the consulates, right?
Oh, right. I forgot that they have a Norwegian passport. So dual nationals aren't affected by the ban.
So you can make the argument, right? Yeah.
Okay, so do you see much hope for the H-1B? Lawsuits are around the 100,000 fee.
Do I see much hope? That's a tricky one. I do think it is extremely well thought out. So it is not like Trump 1.0, first presidency, where almost everything got struck down. So if you're saying hope, yes, there's a little hope that it could be like overturned or overruled. But I also think it is very well thought out. That is within his executive power, and it didn't impact as many people as the media makes it out to be, right? And so there's much less motivation to actually challenge it. So that's the part of the difficulty and rationale why how well thought out that is.
Yeah, I remember some of the challenges, not on the H-1B, but on what we talked about earlier, the notice of violation is like, these are unreasonable fees. So it's almost like cruel and unusual punishment. Like there's got to be some sort of limit. But I don't know how they're actually going to decide what's reasonable, what's unreasonable.
And it has to go through the court system, right? You have to have a plaintiff that is subject to this and finds it so unreasonable and is not in the public interest, and you want to argue it, and then you go through the federal court and you make it contested, and then a ruling will come out. right? So, maybe there's nonprofit organization, the WCF, that's going to represent certain people and challenge it. Maybe or maybe not, right? But it has to work through the legal process. Now, this fine, right? The $998 per day, the $500 a day has always been on the books. With inflation, with the ICE budget, maybe it has gone up. Is that unreasonable? Is that reasonable? Right? I mean, it was always there. So unless you're saying the original one's also unreasonable, right? So I think it's gonna be hard. I do really hate the fact that it's only 15 days, right? I mean, come on, at least 30. Given 90, 15 days. Goodness gracious, right? So many people are gonna miss that 15-day mark.
Right. So I'm waiting on H-1B approval since my company has already filed for me, and my dependent has H-4B, and they do have an approval I-140. My company is responsible for filing the H-1B for me and my dependents. I just need to check with you because my spouse is on F2, has not been able to work. So with an H-4B, can he apply for an EAD?
Yes. So because the I-140 is already approved, once they change the F2 to the H4 dependent, then they could apply for the work permit and they can work.
Okay, so going back to this Afghanistan, Norwegian B1,
Yes.
B2. So B1, B2 was approved for my husband, had been in the U.S. over 5 times when he interviewed for 730, Iowa 730.
Okay.
Now, the officer in Sweden put him on 221G. He applied for B2 again, and they denied it.
Yeah, it's hard. That's definitely hard. But like I said, you can only keep on trying, right?
Right. And is there any specific documents or kind of strategy to be like, I'm definitely going for this B2?
Right. And again, the reason why officers deny the B1, B2 mostly is because they don't think you're going to comply with the B1, B2 requirements, right? And so it's best to go back to the mental framework of your husband at that interview. Why did the officer deny? What did they say? And you can apply again, and you can always ask, what can I do to apply next time to make my case better? I know you can't guarantee the next officer, but you can always ask that, right? And the officers, they also feel bad, but they have to comply with the law as well. And so having a quick 1-minute conversation is within that possibility.
Interesting. I've never heard that ask the officer why or what they could do different next time.
Yeah, I mean, these are just people. These are just people that they have a long day. They're working really hard. You treat them with a lot of respect. If they denied you, ask a little bit about the rationale, right? And how you want to do it better, especially you applied for so many times, right?
How many days before the current reentry permit expires can one apply for the new reentry permit for green card holders?
How what? What?
How long before the current reentry permit expires can you apply for a renewal?
We usually do it within 3 months, but I have to look up exactly USCIS guidelines if you could apply sooner. But almost all of our clients do it within the 3-month period.
And how long does it take to get biometric appointment in LA?
We're seeing about 5 weeks maybe now. Yeah. So after you file, they get it. Then 5 weeks, 6 weeks, then you get the appointment notice.
So on the 39 country ban, we mentioned, what does it mean by class action suit? Does someone have to be a part of the plaintiffs to get the court order benefit?
Yes. You could always join. You could file a new one, but you have to be part of that litigation group in order to get the benefit of moving their case forward. For now, until the courts really strike down that order, then it suddenly becomes obsolete, and then now everything should move forward. But then again, the next executive order could come out and just modify a little bit, and it's back in place, right? So there's just a small sliver of window opportunity for those plaintiffs.
Yeah, some what I was seeing online was, if these judges are already signaling that they will strike it down, then it's not worth joining a lawsuit because the law will probably be struck down. If a lot of judges are striking it down, it'll probably just change. What do you think about that?
Totally makes sense. It's a gamble. Right.
So just like how quickly do you need it?
If you join it, you pay the money, you hire the attorneys, you file the lawsuit. Now you're part of the process and you can expedite.
My current F1, so I'm currently on F1. 45 is pending. Can I terminate F1 with my I-140 approved and 765 and I-31 pending as well?
So based on immigration law, because you already filed the 45, technically, if you choose to do that, and if everything goes smoothly, you can still get your green card. So if your question specifically, you're on F1, you filed the 45 and everything is going forward, can you just terminate the F1? If you're asking the outcome, potentially, can you still get the green card? The answer is yes. You're not legally required to stay on the F1 for this process. However, is it safe to do that in this environment? Even the past administrations, we've always advised clients stay on the F1 all the way until you get the green card. We just say that because we see too many horrendous situations where the 45 inadvertently gets denied for whatever reason. But if you have your F1, you have the opportunity to refile. So generally speaking, we would not advise people to cancel their F1. Our clients specifically, we don't advise them to cancel F1. Have we seen clients who cancel their F1 and they still get the green card? Yes. But that is a big gamble.
So what should this B1, B2 do now? What's the next step? For additional, they have medical issues too. The doctor faxed the letter to the embassy in Sweden. Yeah. But what should they do next? Like, what are the concrete next steps?
Just apply again. DS-160, get us another interview, double the amount of work that you prepared, right? So if you had 5 documents, 10 documents to prove whatever you were trying to argue, double it. That's what we do, right? I forgot what kind of gambling method that is, but I take that and put it in my legal work, right? If a case got denied once, next time I'm just going to double it, right? And then you can deny it again, I'm going to double it again, right? And I do that with my EB1A cases. I do that with a lot of different cases. And now, when you double it, I don't mean like give trash argumentation, right? Or just, but, that the B1, B2 law is very vague. And if you are able to understand where the officer is coming from, and you know probably what they're thinking, you presented this set of documents. They're not convinced. Okay, we'll double it again, right? They're still not convinced. Okay, double it again. And each time you're going, you're just doing your absolute best to present. And hopefully one day it gets approved, right? Just like that one client who, after like 17 tries, and then got approved on the 18th time, right?
Okay, that is our time for today.
Thank you guys for watching. Appreciate it. We're going to break these down into separate videos, and we'll be posting it. And you could rewatch it on our YouTube channel if you're watching from TikTok or Instagram. But thank you guys for watching, and I'll see you guys next week.
Thank you, everyone. We will end, and we will end, and we